हेलो। ये हैंड आउट कहाँ है? Hello, welcome everyone. Welcome. So we are at almost second last day of our RTFQ for Polity, and we will be discussing few questions on these topics. आज के जो हमारे topics है, these are kinds of miscellaneous topics जो हमारे रहते थे: सेंटर-स्टेट रिलेशनशिप, इमरजेंसी प्रोविजंस, इलेक्शंस, पब्लिक सर्विस कमीशन एंड पंचायती राज इंस्टीट्यूशन. So we are going to discuss questions on these topics, and then what we will be doing that once we cover till the whole of 500, जब हमारा पूरा 500 का क्वेश्चन का डिस्कशन कंप्लीट हो जाएगा, so in that after that what we will do that एक कंपाइल्ड जितने भी क्वेश्चंस हमने डिस्कस किए हैं और उनके आंसर कीज, इन सबको हम टेलीग्राम ग्रुप पे यू कैन टेक इट, राइट. सो लेट्स स्टार्ट दिस डिस्कशन. जब हम 500 कंप्लीट कर चुके होंगे, then you will be getting the answer keys along with the questions. वो सब you can download from our official telegram channel, right? Okay, so let's start with today's question, and we will be starting with question number 342 till 341 we have already discussed. उसमें we have seen till various provisions like judicial system, judiciary, high court, supreme court. This was the last time we met and discussed about those topics, right? So let's start with this. First question says that it is about the elections. So few questions in the starting will be about the elections. It is saying all elections in India are based upon a single member constituency, first past the post system and bicameral legislation. Second, the first general elections were held in India in the year 1950 following the ratification of constitution. Which of the statement is or are correct? Which of the statement is or are correct? So this we have to find here. तो इन दिस आंसर शैल बी डी, क्योंकि इसमें से दोनों में से नीदर आर द करेक्ट. इट इज टॉकिंग अबाउट ऑल द इलेक्शंस इन इंडिया. So not all the elections are conducted on the basis of first past the post system. We have several elections like elections of the president, election to elect the members of the Rajya Sabha. All those things are conducted by the way of proportional representation through single transferable vote. And this is talking about the first general election. This was not in 1950. So it was in 1952 December, in 1951 से start हुआ था, but it we take the year as 1952. So here neither of the statement is correct, right? Question number 343 says, which of the following constitutional amendment acts reduced the age of voting from 28 to 18 years? किस amendment act से जो voting age है 21 साल से घट के 18 साल तक हो गई थी, and for the Lok Sabha as well as the assembly election. So you would be knowing that we have two different ages. One is for voting age is 18 years for every elections, but the age to contest the elections are different. कौन से इलेक्शन में कितने ईयर्स पे कंटेस्ट किया जाएगा? देन फॉर पंचायती राज वी हैव 21 years. Persons above 21 years can contest the election for panchayati raj. Then members of the Lok Sabha and Legislative Assembly 25 years. Members of the Legislative Council and Rajya Sabha, their age needs to be 30 years. तो ये अलग अलग एज हैं जो हमारे कॉन्स्टिट्यूशन में प्रिस्क्राइब्ड हैं. द वोटिंग एज इज नाउ 18 year. अर्लियर इट वाज 21, so it was reduced by 61st Amendment Act in the year 1989. So 61st Amendment Act 1989 reduced the age of voting from 21 to 18. Question number 344 says, disqualification on the grounds of defection for a member of parliament will not apply if he goes out of his party as a result of merger with another party, if he has voluntarily given up his membership of the political party, if he abstained from voting or in the contrary to direction of the party, if a nominated members of the house joins a political party after 6 months. So anti-defection is the rule which is prescribed under the 10th schedule of Indian Constitution. 10th schedule हमारे constitution में anti-defection का rule prescribe करता है. So basically the motive was to bring stability to the government so that persons who are winning elections on one party ticket do not change their party after getting the mandate of the people. So there are three categories of people: person who won on a party ticket, person who won on independent, and other are the persons who are nominated. So these persons who are nominated from different walks of life, they have this 6 months. If they want to join any political party, they can join. But if they join any political party after 6 months of their nomination, they shall be disqualified. So this statement is true, he will be disqualified, right? If he and any person who has been elected from any party ticket, after getting elected, he resigns from the political party. It doesn't matter whether he joins any party or not. Simply, if he resigns, he will be disqualified. Secondly, if he resigns and joins any other political party, they will also be disqualified, right? तो बहुत सारे ऐसे ग्राउंड्स है. फर्स्ट वाला स्टेटमेंट भी बोलता है क्या, पर्सन हु गोज आउट ऑफ हिज पार्टी एंड एज ए रिजल्ट ऑफ मर्जर, जब उस पर्सन की पार्टी ही दूसरे पार्टी में मर्ज कर जाए विथ अ 2/3 ऑफ मेजोरिटी, देन दिस इज एन एक्सेप्शन, और उस समय जो भी मेंबर है वो डिस्क्वालीफाई नहीं होता है. क्वेश्चन क्या कह रहा है कि डिस्क्वालिफिकेशन ऑन द ग्राउंड्स ऑफ डिफेक्शन विल नॉट अप्लाई. तो किस सिचुएशन में वो पर्सन सेव हो जाएगा, ही विल नॉट बी डिस्क्वालिफाइड. So on all the other situations he will be disqualified, but on first ground he will not be disqualified. Our answer is A, क्योंकि इस situation में there is an exemption given and the person shall not be disqualified even if the party is merging with another party with a 2/3 majority, right? Question number 345. Let's see question number 345, which says which of the following amendments to the Constitution of India capped the maximum number of council of minister. To the strength of the council of minister cannot go beyond the 15% of the popular house. Which amendment brought out this rule? The answer is C, 91st amendment brought out this rule, and the year you want to note is 2003. तो 91st Amendment Act 2003 से एक रूल आई कि मैक्सिमम स्ट्रेंथ ऑफ द काउंसिल ऑफ मिनिस्टर कैनॉट गो बियॉन्ड 15%. सो इफ यू टॉक अबाउट द यूनियन गवर्नमेंट, यहाँ पे पॉपुलर हाउस यूनियन गवर्नमेंट के कौन होता है, लोकसभा. सो मैक्सिमम स्ट्रेंथ ऑफ द काउंसिल ऑफ मिनिस्टर ऑफ द यूनियन गवर्नमेंट शैल बी 15%, तो अराउंड 80-81 के आसपास आएगा. Similarly, if you are talking about the council of minister of any state, it should be 15% maximum of the legislative assembly. But there is one exception to this rule, which is given under Article 239AA. That is for the government of NCT Delhi. दिल्ली की जो सरकार है उसमें जो मिनिस्टर्स होते हैं उनकी जो मैक्सिमम लिमिट है, द मैक्सिमम नंबर्स ऑफ मिनिस्टर इन द गवर्नमेंट ऑफ दिल्ली कैन बी 10% ओनली. तो बाकी सबके लिए जो रूल है वो 15% है, बट दिल्ली के केस में एक एक्सेप्शन है, दिस इज फॉर 10%, राइट. So our answer to 345 is C. Let's move on to 346. Consider the following statement. The power of superintendence to all the election of the parliament, state legislature, president and vice president of India is vested in the election commission of India. तो इतने सारे इलेक्शंस के लिए, लोकसभा के इलेक्शंस, राज्यसभा के इलेक्शंस, स्टेट लेजिस्लेचर के इलेक्शन, प्रेसिडेंट और वाइस प्रेसिडेंट के इलेक्शंस, इसको कंडक्ट कराने की जो जिम्मेवारी है, द पावर टू कंडक्ट सुपरिटेंडेंट is lying with the Election Commission of India. But the election to the Panchayati Raj institutions, the municipalities, are conducted by the state election commissions, right? Then the second statement says Article 324 vests the power in the election commission to prepare the electoral roll for elections except that of president and vice president. तो आर्टिकल 324 की एग्जैक्ट लैंग्वेज लिखी हुई है, लेकिन यहाँ पे द डिफरेंस इज Election Commission has the power to conduct these elections and also to prepare the electoral roll. इन सब elections के वोटर लिस्ट भी बनाने की पावर है इलेक्शन कमीशन के पास. तो दिस स्टेटमेंट इज फॉल्स, क्योंकि प्रेसिडेंट और वाइस प्रेसिडेंट के इलेक्शन के भी जो वोटर लिस्ट है वो कौन प्रिपेयर कराती है, इलेक्शन कमीशन ऑफ इंडिया. अगर यहाँ पे हम लिखते इफ वी वुड हैव रिटन पंचायती राज इंस्टीट्यूशन, देन दिस पावर शैल गो विद द स्टेट इलेक्शन कमीशन, राइट. बट अदरवाइज फॉर द इलेक्शंस ऑफ द प्रेसिडेंट एंड वाइस प्रेसिडेंट, the power to prepare the electoral roll lies with the Election Commission of India. This statement is false. First is true. Answer is A, right. Now let's consider the next question. Question number 347 that says consider the following statements. Regional election commissioner can be appointed by the chief election commission after the prior consultation of the president. Second, regional commissioners shall not be removed from the office except on the recommendation of chief election commissioner, right? So first statement is false because the power of appointment is not with the chief election commissioner, it is lying with the president. So president can appoint the regional election commissioner, not the chief election commissioner. Now what is the process of removal? So only one out of the election commissioner, that is chief election commissioner of India, he has got a security of tenure. He can only be removed in the same manner as a Supreme Court judge. But other election commissioner, like presently we have an election commission which is a 3-member body, जिसमें से एक chief election commissioner होंगे, other election commissioners होंगे. So this chief election commissioner can only be removed as in the same manner by as the judges of Supreme Court of India are. But the other 2 election commissioners can be removed by the president on the recommendation of chief election commissioner. So can be the regional commissioners. The regional election commissioners can be removed from the office upon the recommendation of the chief election commissioner. So answer shall be B. 348 question number, as per the provisions of the constitution, the members of the scheduled caste, scheduled tribes and other backward caste shall be given reservation in the seat of House of People. The reservation of seats in the House of People in the favor of Anglo-Indians shall be 80 years from the date of commencement of this constitution. तो ये जो क्वेश्चन है बात करता है, this question talks about reserving the seats in the elections for scheduled caste, scheduled tribes. So as a general rule, you should know the constitution has provided for reserving the seats for scheduled caste, scheduled tribes and also for the Anglo-Indians इसमें लोकसभा के इलेक्शंस में या स्टेट की लेजिस्लेटिव इलेक्शंस में there is no provision of reserving seats for women or even for the other backward classes, right? So this is first rule. Secondly, it says that these provisions in the constitution originally was incorporated for a 30 years period. 30 साल की समय के लिए ही ऐसे रिजर्वेशन की घोषणा की गई थी हमारे कॉन्स्टिट्यूशन में. So these were a temporary period and it was thought to expire after a period of 30 years, right? Then from every 10 years, what we do, we extend these reservations. तो पहली बारी हमने इसको 66th अमेंडमेंट में बढ़ा दिया. सबसे पहली बारी 44th अमेंडमेंट एक्ट में इन द ईयर ऑफ 1980, क्योंकि देखो 1950 में हमारा कॉन्स्टिट्यूशन आया, 30 years तक वी हैड गिवन दिस रिजर्वेशन. सो व्हेन इट केम टू 1980 वी एक्सटेंडेड फॉर अनदर 10 years. Then again in the 1990 we extended for another 10 years. ऐसे करते करते it was till 95th constitutional amendment हम 70 साल तक पहुंच गए थे. So till 95th constitutional amendment the reservations were given to SC and ST which could expire at 70 years. एंग्लो इंडियंस को भी 70 साल तक की रिजर्वेशन 2 लोगों की नॉमिनेशन के लिए दी हुई थी. बट व्हेन इट केम आफ्टर 2020, so government enacted 104th constitutional amendment act. Government enacted 104th constitutional amendment act. Parliament enacted rather, not government. So Parliament enacted 104th constitutional amendment act, and in that the reservation to scheduled castes and scheduled tribes has been extended for another 10 years, and that is now 80 years. So 1950 से 80 साल कितने होते हैं? 2030 तक की वो वैलिड रहेगा. Now the Anglo-Indians were also given the two seats in the Lok Sabha, but these could expire at 2020. 2020 में जब 104 when we brought out this 24th Amendment Act, we did not extend this provision. तो अभी क्या है? Presently after 2020 there is no seats which have been reserved for Anglo-Indians. Now it is ceased to expire. तो ये कब एक्सपायर किया? 80 साल में नहीं एक्सपायर किया, ये 70 इयर्स में ही एक्सपायर कर गया. बट इफ यू टॉक अबाउट शेड्यूल्ड कास्ट एंड शेड्यूल्ड ट्राइब्स, द प्रोविजन सेज इट शुड एक्सपायर आफ्टर 80 इयर्स. हालांकि फिर से 10 साल बाद हम उसको बढ़ा ही लेंगे. सो दिस स्टेटमेंट इज फॉल्स, राइट? फर्स्टली दिस आर्टिकल क्वेश्चन नंबर 348 का सेकंड स्टेटमेंट फॉल्स है, राइट? नाउ लेट्स सी अबाउट दैट. एज पर द प्रोविजंस ऑफ कॉन्स्टिट्यूशन, शेड्यूल्ड कास्ट, शेड्यूल्ड ट्राइब्स, अदर बैकवर्ड क्लासेस शैल बी गिवन द रिजर्वेशन. मैंने क्या बोला था? सिर्फ शेड्यूल्ड कास्ट, शेड्यूल्ड ट्राइब्स एंड एंग्लो इंडियंस के बारे में है. there is no reservation for other backward classes. This statement is also false. Answer shall be D. कोई भी नहीं सही होगा. Now let's move on to question number 349. Which of the following is not a correct statement about the principles of general election? There is one electoral roll for every territorial constituency. This is true. Equality has been accorded to each citizen in the matter of franchise on the secular basis. This is true. Article 325 says no citizens can be excluded. किसी को भी no citizen can be excluded from getting his name entered into the voter list on the grounds of religion. तो धर्म के आधार पे ही सिर्फ किसी को हम वोटर लिस्ट से बाहर नहीं कर सकते, वोट देने से मना नहीं कर सकते. तो दिस इज एस्टैब्लिशिंग द सेक्युलर फ्रेंचाइज on the secular basis. Thirdly, it says Constitution of India has enabled state to provide reservation on seats for socially and educationally backward classes, women and Anglo-Indians. अभी जो हमने किया discuss, it is about the same. So which is not a correct statement, because we do not provide reservations for women, we do not provide reservation for socially and educationally backward classes, rather we explicitly did for SCs, STs and Anglo-Indians. So this statement is false. Fourth one is also true, that a person once convicted for a specified offense, ये representation of people's act में mentioned है, that a person once convicted, they are debarred from contesting election also, and they are also debarred from voting for a period of 6 years. एक बार किसी को सजा हो गई तो 6 साल तक के लिए वो वोट भी नहीं दे सकता. At this point of time, एक additional fact you should know, that there is a difference between getting convicted, सजा होना, and getting arrested. Suppose that there is a person who has been arrested, right, and then he is given the sentence. So यहाँ पे बोलते हैं जब उसको दोषी मान के, if he has been declared guilty, then only he will be disqualified, right? But what about the persons who are under arrest, who are put in jail, right? So the persons who have been arrested and they are locked up in the jail, they will also not be eligible to vote. But those persons who have been arrested on the grounds of preventive detention, they are allowed to vote. तो arrested person जिनके ऊपर केस चल रहा है, those judgment has not been finalized and they are within the jail, अगर जो bail पे बाहर है, they can vote. But those persons who are arrested, who are facing trial and they are locked up in the jail, so they will not be allowed to vote. But if those persons are arrested on the grounds of preventive detention, they are allowed to vote. तो एक additional information था. बहरहाल हमारे क्वेश्चन का आंसर है सी. क्वेश्चन नंबर 350. Which of the following is the part of basic structure which evolved during the case 1 and the Bharti case? So you should be knowing that recently it was the 50th year of the case 1 and the Bharti case. The judgment came on 24th of April 1973, and the last week it was 50 years of the case 1 and the Bharti case. So in that case, separation of power, unity, integrity of the nation, federal character and judicial view, all of them were held to be the basic structure, to be the part of the basic structure of the constitution, right? इसके बारे में जो डिटेल में नोट्स है और एक्सप्लेनेशन है, you will be getting this in the handout, और जिसको आप कहां से डाउनलोड करोगे, तो टेलीग्राम चैनल से you can download it, right? With reference to question number 351, with reference to committee for the appointment of election commissioners and chief election commissioners, consider the following statement. It consists of prime minister, leader of opposition in the Lok Sabha and 4 senior most judges. तो ये क्वेश्चन थोड़ा करंट अफेयर्स ओरिएंटेड है, एंड रिसेंटली द कॉन्स्टिट्यूशन 5 जज कॉन्स्टिट्यूशन बेंच ऑफ द सुप्रीम कोर्ट हैज गिवन अ वर्डिक्ट अबाउट द अपॉइंटमेंट एंड सिलेक्शन ऑफ द इलेक्शन कमिश्नर. चीफ इलेक्शन कमिश्नर कैसे अपॉइंट होंगे, सिलेक्ट कैसे होंगे, उसके रिगार्डिंग सुप्रीम कोर्ट ने एक जजमेंट दिया है दैट सेज दे शुड बी अपॉइंटेड बाय द प्रेसिडेंट ऑन द रिकमेंडेशन ऑफ अ कमिटी which shall be consisting of prime minister, opposition member, leader of opposition in the Lok Sabha, and ये वाला गलत है, not 4 senior most judge, chief justice of India, right? Secondly, in the absence of the leader of opposition, the committee will not include the leader, committee will include the leader of the largest opposition party in the Lok Sabha in terms of numerical strength. यानी कि अगर कोई leader of opposition नहीं है, because see there is an act of 1971 that says that leader of opposition should be from those party which is having at least 1/10 of the strength in the Lok Sabha. लोक सभा में जिसका अगर 1/10 स्ट्रेंथ है, ओनली दैट पार्टी शुड बी डेजिग्नेटेड, और वहां का जो लीडर होगा दे विल बी कॉल्ड लीडर ऑफ अपोजिशन. बट देयर मे बी अ सिचुएशन लाइक इट हैपेंड इन 2014 that there was no party which achieved this number of 54, so there was no designated leader of opposition. In that situation what happens that there are several committees where the leader of opposition is the member, तो वो खाली हो जाती हैं. So in that situation this provision says कि अगर कोई leader of opposition designated नहीं है, so in that case जो सबसे बड़ी opposition party होगी उसका leader मान लिया जाएगा. So this statement is true. First one is false because it is not 4 senior most judges, it is rather the Chief Justice of India, right? So question number 351, the answer shall be B. S3WASS, this is often heard in news, so the current affairs का है. So basically it is a platform, cloud-based platform where themes are present in government can build up their website. So answer will be 1. It is a cloud service developed for government entities to generate secure, scalable and Sugamya. That is Sugamya means accessible website, right? So answer for this is A. Which of the following statement is not correct about the governor of Indian state? The state governor shall be appointed by the president by warrant under his seal and hand. The qualification and condition of the office are mentioned in the constitution. Governor shall hold the office for fixed period of 5 years. There is no impeachment process for removal of government. This is governor. This is true, right? Now see, let's see on this statement that it says it hold office for a fixed period of 5 years. अगर यहाँ पे सिर्फ 5 years लिखा होता नॉट द फिक्स, देन दिस स्टेटमेंट वुड बी ट्रू, बिकॉज कॉन्स्टिट्यूशन में मेंशन तो है द गवर्नर शैल बी होल्डिंग द ऑफिस फॉर अ पीरियड ऑफ 5 years, बट दैट इज नॉट अ फिक्स्ड पीरियड ऑफ 5 years बिकॉज दिस 5 years इज सब्जेक्ट टू द प्लेजर ऑफ प्रेसिडेंट, सब्जेक्ट टू द प्लेजर ऑफ प्रेसिडेंट. तो जब भी प्रेसिडेंट चाहे he can remove the governor and there is no process of impeaching the governor also. So this is not a fixed period of 5 years. This statement shall be false. Answer shall be C. Which of the following state is not included in the sixth schedule? Sixth schedule areas में autonomous district council होते हैं and out of these 4 the option C, that is Manipur, ये जो है वो 6th state में नहीं है, सॉरी 6th schedule में नहीं है. तो 6th schedule is applicable for governing the tribal areas and it is applicable to Assam, Meghalaya, Mizoram and Tripura. Assam, Meghalaya, Mizoram and Tripura. मणिपुर इन चारों में से नहीं है. So this is a false statement. Now moving on, question number 355, which says with reference to the Vice President of India, consider the following statements. He or she is elected by the members of an electoral college consisting of members of both the houses of parliament. Second, the system of proportional representation by the means of single transferable vote is used in the election. Third, all doubts and disputes arising out of or in the connection with the election of president or vice president shall be inquired to and decided by the Election Commission of India. So they shall not be decided by the Election Commission of India. They shall be decided by the Supreme Court. तो elections of vice president और प्रेसिडेंट के जितने भी डिस्प्यूट्स होते हैं वो कौन सेटल करता है? तो सुप्रीम कोर्ट करता है. और ऐसा कहाँ मेंशन है? इट इज मेंशन्ड अंडर आर्टिकल 71 सब क्लॉज 1 ऑफ द कॉन्स्टिट्यूशन, राइट? सो द थर्ड स्टेटमेंट इज फॉल्स. आंसर शैल बी डी, दैट इज 1 and 2 इज करेक्ट. Question number 353. Yes, so qualifications and conditions of office are mentioned. There are conditions of office that it cannot be reduced. They have a fix their salaries. They cannot be reduced once they enter into office. Their conditions cannot be reduced, diminished to their disadvantages. Qualification of age is mentioned. तो वैसा mention करके रखा है. There is a particular article also. The heading ही उस article का है. That says qualifications and conditions of office of the governor. तो ये कॉन्स्टिट्यूशन में मेंशन्ड है, बट इफ इट वुड हैव आस्क्ड दैट इलैबोरेटली इट हैज बीन डिस्कस्ड, तो इलैबोरेटली नहीं है, बट मेंशन्ड है. क्वालिफिकेशंस आर मेंशन्ड इन द कॉन्स्टिट्यूशन. तो एक आर्टिकल है, उसका हेडिंग ही है. देयर इज नो कंफ्यूजन इन दैट, राइट? Moving on, question number 356. Consider the following statements about registered unrecognized political parties. See, so there is a difference between recognized political parties and there is a difference between a state party, regional party or a national party. तो उसी कॉन्टेक्स्ट में करना है. These parties are registered under the Representation of People's Act 1950. So no, it is not registered under Representation of Act 1950. Rather, there is two acts. One is Representation of People's Act 1950 and another is 1951. So basically 1950 wala act talks about the pre-electoral processes. They talks about the qualifications of voters, disqualifications of voters. So all these things are mentioned in the 1950 Act. But from the start of the election process till the conduct and even after issuing the certificates, the disqualifications of the legislators, then punishments prescribed there. So all are mentioned in the 1951 Act. It also talks about registration and recognition to the political parties, right? So pehla statement galat hai. Now second says they will be getting the free authorization of broadcast and telecast facility over all India radio. So this is given to the national political party, national parties, not the recognized, simply registered political party. Jitne bhi parties hote hain, once they get themselves registered with the election commission, they become registered recognized political parties, and out of them few will be given the status of state party and few will be given the status of the national party. So ye is hai, free airtime, free telecast, all these are given to the national political parties, not these registered unrecognized political parties. So jitne bhi political party registered hote hain usko do criteria mein aap baant sakte ho. So political parties has to be registered, and there you will be doing two classification. One is recognized, and out of this you will be state party and another will be national party. So ye jo privileges hain, these are applicable to the recognized state or national party. They are not applicable to unrecognized political parties, right? तो ये statement भी false हो जाएगा. दोनों में से कोई भी सही नहीं है यहाँ पे. Moving on, question number 357. At the national level, which ministry is the nodal agency to ensure the effective implementation of scheduled tribes and other traditional forest dweller recognition of Forest Right Act 2006? So 2021 का question है, पूछा हुआ, the Ministry of Tribal Affairs is the answer for it. Ministry of Tribal Affairs is the answer. Question number 358, with reference to anti-defection laws in India, it's again a previous year question which has been asked in 2022. The law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the particular house. हमने अभी भी डिस्कस किया था that a person who has got the nomination to any house, if they want to join any political party, they get only 6 months. If they join any political party within 6 months of their nomination, they shall not be disqualified. But if they join after 6 months, they can get disqualified. तो ये उल्टा statement है. They can join within 6 months, but they cannot join after 6 months. Secondly, the law does not provide any time frame for frame within which the decision has to be taken by the speaker, right? So ये जो statement है सही है. This is true. First one is false. See, the power to decide that whether the person shall be disqualified on the grounds of anti-defection, on the grounds for anti-defection, so this shall be decided by the speaker of the respective house, right? And but there is no such time frame which has been given for that decision. His decision, speaker decision, is final and binding. That means there will be no appeal against it, right? So this option should be B. Again, there is a previous year question of 2017. Right to vote to be elected in India is a fundamental, natural, constitutional and legal right. So it is declared as a constitutional right. इसमें बहुत doubt होता है लोगों को, and there are various persons who will tell that it is right to vote. But it is a settled principle that it is a constitutional right. It has been upheld as a constitutional right by the Supreme Court also. And you will find the various sources, including the MP Jain का जो किताब है, that has elaborately discussed why right to vote is a constitutional right and not merely a legal right. क्योंकि legal right को कम protection है, right? It can be changed, it can be taken away by another ordinary legislation. But right to vote cannot be so simply taken away. It can only be restricted on some grounds. by the laws which are made by the parliament. That suppose that a person has become insolvent or has gone insane of unsound mind or has been convicted of an offense, then only in those criteria they will not be allowed to vote. But otherwise, that is the feature. So free and fair election is the basic feature, and right to vote, that becomes a part of it. So it is a constitutionally granted right. So there shall be no doubt that it is not a constitutional right. It is already established that it is a constitutional right, right? So हमारा जो आंसर है, आंसर shall be C, right? Akash Pesa Panchayati Raj extension is implemented by which ministry? So it is implemented by Ministry of Panchayati Raj. Next question, question number 360, that says, if the President of India exercises his power as provided under Article 356 of the Constitution, this in the respect of the particular state, then what is the necessary implication? The assembly of the state is automatically dissolved. This is not true. It can either be dissolved or kept in suspended motion. The powers of the legislature of the state shall be exercised by or under the authority of the parliament. This is true statement. Article 19 is suspended in the state. Article 19 का कोई इफेक्ट स्टेट इमरजेंसी पे नहीं होता. Article 19 is suspended only if there is a national emergency. So there are two articles, which is Article 358 and 359. It talks about suspension of fundamental right during imposition of national emergency. During the state emergency, that is the president rule, Article 19 is not suspended. So the correct answer here shall be B. Question number 361. Consider the following statements. The minimum age prescribed for any person to become a member of panchayat is 25 years. This is false. हमने शुरू में ही देख लिया था. That is 21 years. A panchayat reconstituted after the premature dissolution continues only for the remainder period. Right. So see, usually the tenure of any panchayati raj institution, gram panchayat, is for 5 years. Right. But suppose that in the 2014 there was an election, and ideally it should have continued to 2019. But in the meanwhile, in the 2017, for any matter, the panchayat, the election has to get dissolved. Then within 6 months there has to be a fresh election, and जो election होगा, that will continue only till the remainder period. So the freshly constituted panchayat shall go only till the remaining period. वहां से उसको 5 साल extra नहीं मिलेगा. It will terminate at the original 5 years, that is 2019 में ही. So जो एक बार termination के बाद जो पंचायत बनती है, they get only the remaining tenure, not the full tenure. So this is a true statement. This is a false statement, right? So answer shall be B. यहाँ पे कुछ errors के कारण there are 7 questions which have been left as blank. We will compensate that in our next discussion. Not to worry about that. So there will be more than 500 questions, around 510 questions we shall be discussing. So just to maintain this sequence, we'll directly go to the question number 369. All those missing questions will be put in the next discussion. What was the subject of Vohra committee? Vohra committee की किसके ऊपर बनाई गई थी? So Vohra committee was upon the criminalization of politics, electoral reforms के ऊपर था. So nexus between crime and politics. Question number 370. Consider the following statement. For the parliament to make laws with respect to any matter enumerated in the state list, a resolution must be passed in both the houses of parliament. Now, second, a resolution passed under Article 249 cannot extend beyond 1 year. तो दो चीजों के बारे में बात करता है. So can parliament make laws in any matter which is given in the state list? Ideally, parliament cannot make, because the state list are the powers of the state. But our constitution prescribes for certain situations wherein parliament get this extraordinary power to enact under the state list. One such power is Article 249. So Article 249 says, if the Council of State, that is Rajya Sabha, passes a resolution with 2/3 majority present and voting, 2/3 members present and voting के साथ अगर राज्यसभा एक रेजोल्यूशन पास करती है, then the parliament gets this power. Parliament meaning the Lok Sabha and Rajya Sabha together. But उसके पहले राज्यसभा को एक रेजोल्यूशन पास करना पड़ेगा. तो राज्यसभा हैज टू पास अ रेजोल्यूशन विथ 2/3 ऑफ द मेजोरिटी। यहाँ पे क्या लिखा है, बोथ द हाउसेस से पास करना होगा। दिस स्टेटमेंट इज फॉल्स बिकॉज फर्स्टली अ रेजोल्यूशन हैज टू बी पास्ड बाय Council of State with a 2/3 majority present and voting, then both the houses can together make the laws, right? Secondly, it says a resolution passed under Article 249 cannot be extended beyond 1 year. So this is also false. It can be extended by another 1 year. So दोनों ही स्टेटमेंट यहाँ पे गलत हो जाते हैं। Question number 371. This says consider the following statement about union state relationship. In case of overlapping of matters between three kinds of subject legislation, predominance has been given to the union legislation. We have a strong center, so this is quite an obvious option. Unitary bias, it is showing the unitary bias of our Indian constitution. In the concurrent sphere, in case of repugnancy between a union and state laws, the law relating to the same subject, the former prevails. मतलब कौन prevail करेगा? Union prevail करेगा. Even if the state law was reserved for the assent of the president and has received the such an assent, right? तो ये क्या कहता है कि ideally if there is a conflict between union law and state law on the matters given in the concurrent list, which shall prevail? Union's law shall prevail. But what if there is a situation when state has enacted one act and it was reserved for the consent of the president, assent of the president, and president finally has assented to it. So if any law which has received the presidential assent on any matters which is there in concurrent list, and such laws if was passed by the legislature of the state shall not be subject to the union law. So this law shall prevail. तो ये जो आंसर है वो फॉल्स है, सेकंड वाला जो स्टेटमेंट है फॉल्स है। सो पहली बार आपको ये ध्यान देना है कि if there is any conflict in the concurrent list, so technically union law shall prevail. But if there is any law which has been made by the state legislature and if had received the assent of the president, then that shall prevail. और ऐसा हमारे कॉन्स्टिट्यूशन में लिखा हुआ है, आर्टिकल 254 सब क्लोज 2। ये जब आप पढ़ोगे यू विल गेट दिस आइडिया दैट इफ एनी लॉ ऑफ द स्टेट लेजिस्लेचर हैज रिसीव्ड द assent of the president, that shall prevail, right? So this statement becomes false. The vesting of the residual power under the Indian Constitution follows the president of Canada. तो Canada से हमने लिया है. So technically Article 248 of the Constitution says if there is any subject matter which is not even mentioned in the union, not in the state, and not in the concurrent list, then the power to make laws shall lie with whom? That is called residual power. So residual power lies with the parliament. And हमने इस प्रोविजन को कहां से लिया है? कनाडा से लिया है. आंसर shall be B. हमारा जो आंसर है वो होगा B. 1 and 3 is correct because 2 is a false statement. Question number 372. The All India services violate the federal principle of the Constitution as well as autonomy of the state. All India services कौन होते हैं? IAS, IPS. These are the two All India services, and they are appointed by whom? The center. But they work where? In the state. They are controlled by whom? As per the rules and regulation of the center. So it is thought that this is an interference in the state's autonomy by the appointments of, by the hands of the union. So this has been held as a violation or dilution of the federal principles, right? So the first statement is true. Secondly, all India services are governed by central rules and the state government do not have a full control over them. So चूंकि सेंट्रल गवर्नमेंट का कंट्रोल होता है एंड दे आर वर्किंग इन अ स्टेट इंस्टीट्यूशन, so this is what? Violation of federal. तो ए आर जो है ये इसका रीजन है. आंसर shall be A. Consider the following statements. Parliament shall, while proclamation of emergency in operation, have the power to make laws for whole or any part of the territory of India with respect to any matters enumerated in the state list. तो जब भी इमरजेंसी लग जाती है तो पार्लियामेंट स्टेट लिस्ट में भी दिए गए मैटर्स पे कानून बना सकती है. Second, Parliament has exclusive power to make any laws with respect to any matter not enumerated in union, concurrent and state list. That is the Article 248 residual power. Parliament has the power to make any law for the whole or any part of the territory of India for implementing any treaty or conventions. So basically these are providing for what? The alteration in the legislative distribution of powers. टेक्निकली यूनियन लिस्ट में पार्लियामेंट बनानी चाहिए, स्टेट लिस्ट में स्टेट बनानी चाहिए, और कॉन्करेंट लिस्ट में दोनों बनानी चाहिए. बट दीज आर प्रोवाइडिंग फॉर सर्टेन एक्सेप्शंस दैट वेयर पार्लियामेंट कैन इनैक्ट even in the matters which have been given in the state list, right? Even in the matters which have been given in the state list. ठीक है, तो इसका आंसर जो है क्या है, क्योंकि सारे स्टेटमेंट सही हैं, वी हैव द आंसर करेक्ट एज बी. सारे स्टेटमेंट, ऑल ऑफ दीज स्टेटमेंट्स आर करेक्ट. So in all those situations, Parliament can make the laws even in the state list. State lists में भी किसी भी दिए गए मैटर्स पे पार्लियामेंट लॉ बना सकती है ऑन these 4 situations. If any direction which is issued by the union government to a state under Article 357, so Article 357 क्या बोलता है? The union can give mandatory direction to the states on few issues like maintenance of telecommunication service, safety and security of railways which is going through the particular state. So upon these matters, union can give the direction to the state. But what if the state is not obeying those directions? State उन directions को obey नहीं कर रही है, तो उस situation में क्या होता है? Firstly, it shall be presumed that constitutional machinery has failed in the state. Secondly, it shall be presumed that the state had a law and order problem. Third, union government can appoint advisors to help the governor. Fourth, parliament may make laws for the state. So अगर किसी ऐसे mandatory direction का, if any such mandatory directions which have been given by the union to the state and state is not obeying that, this creates a ground for imposition of precedent rule in the state, and that is construed, that is interpreted that the constitutional machinery has failed in the state. और ऐसा कहाँ लिखा है? आर्टिकल 365 mentions this. So our answer shall be A. 375 says the idea of union giving direction to the state was adopted from, so ये ऊपर वाला जो provision है, that we have inspired from where? So we have inspired it from the Government of India Act 1935, that has contained a provision where union can give instruction to the states. Question number 376, on the subjects of income tax, union government has more power, the state government has more power, both have the equal powers, only union government has power. So income tax, so you will find that we have a union list. In that there is an item which is mentioned, tax on income except agricultural income. So agricultural पे, agriculture से होने वाले income, उसके अलावा जितनी भी income होती है, which is the list which is having that union list. So where, who can make the laws, which institution has the power in the union list? So it is union government has the power, exclusive power to enact upon the matters related to income tax. So income tax के matters पे किसके पास power है? सिर्फ union की government के पास power है. State government cannot make any laws upon the matters of income tax. Question number 377. Consider the following statement. The executive powers of the union extend to giving of directions to a state in the respect of construction and maintenance of means of communication of national or military importance, maintenance of law and order in the state, protection of railways in the state, protection of secular character of the country. So ये जो दोनों हैं, these are mentioned in the Constitution 1 and 3. Maintenance of law and order in the state is the total purview of the state. Union shall not interfere into that. और ऐसा कहीं mentioned नहीं है. So our answer shall be C, 1 and 3. Question number 378. Which of the following formed a part of the terms of reference of the Panchi Commission on the center-state relations constituted by the Government of India? तो इनमें से किन किन मुद्दों पे पंची कमीशन ने रिकमेंडेशंस किए हैं, एंड अपॉन विच ऑफ दिस सब्जेक्ट पंची कमीशन वाज फॉर्म्ड? वन इज पंचायती राज इंस्टीट्यूशन, कम्युनल वायलेंस, एन इंटीग्रेटेड डोमेस्टिक मार्केट, सेंट्रल लॉ इन्फोर्समेंट एजेंसी. तो इन सारे मुद्दों पे पंची कमीशन को रिकमेंडेशन करना था. ऑल ऑफ दीज वेर द पार्ट ऑफ द रेफरेंसेस which were given the mandate. Panchi Commission was given the mandate upon these issues. Question number 379, match the following. So there are two lists. One is source and another is taxes. We have to match it. Taxes levied by Union of India and assigned to the center. जो टैक्स यूनियन लेवी करती है and that is kept with the center. Secondly, taxes levied by union but which are assigned to the state. Collect levy तो यूनियन करती है लेकिन वो दिया किसको जाता है? आकाश, एग्रीकल्चरल इनकम. So union list is mentioning income other than the agricultural income, but if you see the state list, that mentions income upon the agriculture. So agricultural income is the part of the respective state, that is not in the concurrent. Now where were we? So we were discussing about this. So taxes levied by Union of India and assigned to the center, taxes levied by Union of India but assigned to the state, taxes levied by the state and assigned to the state, taxes levied by Union of India and distributed between the union and states. तो एक बार इसको मैच कर लेते हैं. डी का is income tax. So income tax is levied and collected by the union but the share is distributed among union and state. तो डी का होगा जाएगा 1. Then what is C is saying? Taxes levied by the state and assigned to state, right? B is saying taxes levied by the Union of India but assigned to the state. ठीक है? And one is taxes levied by the union and assigned to the center. So this will be surcharges. Surcharges are collected, levied by the union and union, it is kept with the union only. So A का 4 है. Now let's see. Taxes levied by the Union of India but assigned to the state. Interstate goods and trade, trade of goods and services पे जो taxes लगाती है वो यूनियन गवर्नमेंट लगाती है and this is distributed among the two concerned states. तो ये हमारा अब आपके निकल के आ जाएगा आंसर सेल बी डी, क्योंकि डी का हमने 1 देखा, डी का 1. देन यू हैव सी, C for the taxes levied by the state and assigned to the state, land revenue. So C का 2, B का 3 and A का 4. So this is the correct option D. Question 380. Consider the following statements on the zonal councils. The zonal councils were set up under the provisions of the State Reorganization Act 1956. So this is a correct statement. It was set up under this act. Zonal councils discuss various issues of common interest in the field of planning, river water disputes, interstate transport. Third, they enable the center and state to cooperate in the evolving uniform policies. So Zonal Council, State Reorganization Act 1956 के अंदर Zonal Council बनाई गई थी and India was distributed into various zones, north, east, west, central and south. But you would have also heard about the northeastern states, northeastern council, right? That includes the 7 sisters plus Sikkim, right? उसमें ये 8 states आते हैं. But this northeastern zonal council is not created under this particular 1956 act. उसके लिए एक separate act बना हुआ है and that act was created by Northeastern Council Act of 1971. तो Northeastern Council Act अलग है. These zonal councils are for the purpose of ensuring better coordination between the states, right? हमारा क्या होगा ऑप्शन यहाँ पे? सेकंड इज, फर्स्ट इज ट्रू, सेकंड इज ऑल्सो ट्रू, थर्ड इज ऑल्सो ट्रू. Fourth is saying their decisions are binding on the center as well as on state government. So these are simply advisory in nature. These decisions are not binary in nature. Let's see what are the options available for us. 1, 2 and 3 is correct. So our answer shall be A, because fourth one is false. Question number 381. Which of the following bodies do not find mention in the Constitution of India? 2013 का है, थोड़ा पुराना क्वेश्चन है, but it has been asked by the UPSC. So which of do not find mention in the Constitution? National Development Council, Planning Commission, and Zonal Council. So all these were the extra constitutional bodies. They did not find mention in the constitution. Answer shall be D. Zonal councils have been created by the State Reorganization Act. Planning Commission was created by the executive resolution. Now it has been abolished. Now we have Niti Aayog for the replacement of Planning Commission. Let's move on to question number 382. Consider the following statements regarding constitutional provision related to trade, commerce and intercourse. So there is one article 300, 01, 32, 302, 304, 305 तक इंटरस्टेट ट्रेड कॉमर्स के बारे में बात की जाती है दैट देयर शैल बी नो रिस्ट्रिक्शन, नो डिस्क्रिमिनेशन अमंग द इंटरस्टेट ट्रेड अमंग वन स्टेट टू अनदर. एंड व्हाट आर द प्रोविजंस केप्ट देयर? लेट्स सी दैट. First is Parliament may by law impose restrictions on the freedom of trade, commerce or intercourse between one state and another in the public interest. Second, a bill imposing restriction on the freedom of trade, commerce and intercourse within the state cannot be moved in the state legislature without the sanction of the central government. Third, Parliament may enact any law giving or authorizing any discrimination to deal with a situation arising from scarcity of goods in any part of the territory. Fourth, trade and commerce within the state is a subject matter of the concurrent list, right? Is a subject matter of concurrent list. See, so what happens here is that there is usually article 301 that provides that there has to be the freedom of trade and intercourse among the different state, right? But article 302 gives the power. So this freedom of trade and intercourse which have been provided under article 301, it is subject to the other provisions of the constitution. Plus under article 302 तो 302 में ही क्या कर रखा है? पार्लियामेंट को पावर देकर रखा है that parliament can impose restrictions upon such trade and intercourse between the different states in the public interest. And article 303 says that there can be discrimination. A law may be enacted which may be discriminating among different states if there is a scarcity of goods in any part of Indian territory. So कहीं पे scarcity of, suppose that there is a wheat which is a scarcity in there is a wheat crunch in a particular state and now other state is telling to import the wheat from there. Parliament may enact the laws which may say that particular state is facing a wheat crunch. So there have to be put a restriction upon that. So this will not be violating the principle which is under article 301, the freedom of trade and intercourse. तो discriminatory बनाया जा सकता है laws को, but there are certain regulations accordingly which can be done, right? तो हमारा क्या statement जो which of the statement is correct here? First one is true, third one is true, second one is false. It does not require the sanction of the government, and fourth one is also false, right? So our answer shall be C. 1 and 3 only is correct. Question number 383. Article 301 of the Constitution declare trade, commerce and intercourse throughout the territory of India is free. The region says the state can impose taxes which do not directly affect the freedom of trade, Both the statements are individually true, but R is not correctly explaining that why it is free. So R is not the correct region, but both the statements are individually correct. Question number 384. No proclamation of emergency can be made by the President of India unless the Union Minister of Cabinet rank headed by the Prime Minister recommended to him in writing that such a proclamation should be issued. So before that, 44th Amendment Act के द्वारा, by the 44th Amendment Act, there was massive change with regards to the provisions related to emergency in India. Emergency के regarding कुछ provisions को हमने बहुत हद तक we changed by the 44th Amendment Act, but before that there was no mention about the word cabinet. So only place you will find in our constitution the word cabinet is mentioned, that is Article 352. Rest at other places you will find the mention of council of minister, you will find other synonymous word, but the word cabinet is mentioned under Article 352, and the law here says that President can declare the emergency only if there is a written consent by each member of the cabinet in the written format, right? So first statement is true. Second says the President of India must issue a proclamation of revocation of emergency if the Lok Sabha passes a resolution disapproving the proclamation for its continuance. मतलब अगर लोक सभा ने एक रेजोल्यूशन पास कर दिया है with the simple majority, then it is obligatory upon the president that he will have to revoke the emergency. Emergency उनको वापस लेनी पड़ेगी, right? So this statement is true, right? This statement is true. Our answer shall be C. 384 का C is correct. Let's move on to question number 385. Consider the following statement. If the financial emergency has been declared by the president under Article 360, then its proclamation may be revoked or varied by a subsequent proclamation. True. Its proclamation shall cease to operate at the expiration of 2 months unless before the expiration of that period it has been approved by the resolution of both the houses of parliament. So technically national emergency once passed shall be, एक बार national emergency declare करने के, once national emergency has been declared, it should be passed from both the houses within 1 month. But other emergencies like state emergency and financial emergency should be passed by both the houses within 2 months. Within 2 months, right? So it is saying if the resolution of financial emergency is not passed within 2 months, it shall cease to expire, right? So this statement is true. First one, once the resolution has been passed, एक बार financial emergency proclaim कर दी गई, once the financial emergency is proclaimed, it can be taken away by the subsequent proclamation, that is C. So C, both the statement is correct here. Consider the following statements. While proclamation of emergency is in operation, Article 359 of the Constitution of India does not come into operation till an order is issued by the President specifying the rights which were suspended, right? तो दो तरीके से राइट सस्पेंड हो सकते हैं हमारे कॉन्स्टिट्यूशन में. One is Article 358, another is Article 359. 358 says if there is a national emergency which has been declared on the grounds of war or external aggression, then Article 19, the rights which are given under Article 19 shall automatically get suspended. All the other rights except Article 20 and 21 shall be suspended by a separate declaration under Article 359. Second says, while a proclamation of emergency is operation, Article 15 makes the restriction imposed by Article 19 non-existent against the actions of the state, right? So यहाँ भी दोनों statement ही सही हैं. Our answer shall be C. Both the statements are correct. Which of the following are not necessarily the consequence of proclamation of president rule in the state? Dissolution of the legislative assembly, the removal of the council of ministers, dissolution of the local bodies, takeover of the administration by the union government. So dissolution of the state legislative assembly is not a necessary consequence. The state legislative assembly may be dissolved or may be kept in a suspended motion. So that false. First statement is false. Secondly, if the president declares the state emergency, then state council of ministers is removed and all the administration passes in the hands of union government, right? Dissolution of local bodies is also not a necessary consequence. So 2 and 4 is correct. Right? So 2 and 4. Oh, sorry, we have to do not necessarily. So not necessarily is 1 and 3. 1 and 3 is not necessarily having. बाकी दोनों removal ये necessary होगा. This is mandatory, right? And this is also mandatory. So we were asked that कौन सा necessary consequence नहीं है. तो यहाँ आंसर है हमारा B, that is 1 and 3. Question number 388. Consider the following statements. Proclamation of emergency under Article 352 of the Constitution requires written communication of the cabinet. We have already seen. Can be issued for the whole of India or any part. Yes, it can be. National emergency can be applied throughout the India or for any particular part of the territory of India. it lapses if not approved by both the houses of parliament within 1 month. National emergency should be passed by both the houses within 1 month. Other two emergencies 2 months. It requires a resolution approving the proclamation emergency should be passed by both the houses of parliament by a majority of total membership of each house, not less than 2/3 of the members present and voting. Once approved, once approved by the parliament, emergency continues for a period of 6 months. However, further it can be extended for every time by 6 months each. 6 months karke it can be continued till indefinite period of time, the national emergency. But there is a limit on the state emergency. It can only be extended till 3 years. 3 साल से ज्यादा state emergency को हम नहीं ले जा सकते. Here we have seen that all of the statement are correct. Our answer is A. Question 389. The law made by the parliament with respect to any matter enumerated in the state list during a proclamation of national emergency will cease to have effect in which of the following? When proclamation of emergency has ceased to operate, when it is repealed by the parliament on the expiration of 6 months after the proclamation of emergency has ceased to operate. D. On the expiration of 1 year after the proclamation of emergency has ceased to operate. मतलब we already know that once national emergency have been imposed, parliament gets the power to make the laws even in the state list. So what if the law has been made by the parliament? What is the duration for that? So if parliament has made any law during the situation of national emergency, and that law should cease to have effect once the national emergency has expired 6 months after that. तो एक बार नेशनल इमरजेंसी के दौरान अगर पार्लियामेंट ने कोई लॉ बनाई है इन द स्टेट लिस्ट, जिस दिन नेशनल इमरजेंसी खत्म होगा उसके 6 महीने के बाद वो लॉ खुद ही इनइफेक्टिव हो जाएगा. तो द आंसर हियर इज सी. क्वेश्चन नंबर 390. Which of the following statement is correct one? War, external aggression, internal disturbance, and armed rebellion are the grounds for proclamation of national emergency. Word armed rebellion were replaced by the word war by the 44th Amendment Act. Actual existence of any or more grounds mentioned in the Article 352 is necessary. The President proclaims the emergency on the basis of any ground mentioned in Article 352 or possibility thereof. Right? यहाँ पे देखिए वॉर, एक्सटर्नल एग्रेशन, इंटरनल डिस्टर्बेंस इज नॉट देयर, इट हैज नाउ बीन रिमूव्ड. वर्ड आर्म्ड रेबेलियन वर रिप्लेस्ड बाय, वर्ड आर्म्ड रेबेलियन को रिप्लेस नहीं किया गया था, वर्ड इंटरनल डिस्टर्बेंस वाज रिप्लेस्ड बाय आर्म्ड रेबेलियन इन द 44th अमेंडमेंट एक्ट. तो दिस इज आल्सो फॉल्स, दिस इज आल्सो फॉल्स. एक्चुअल ग्राउंड्स का एग्जिस्टेंस होना नहीं. इफ इवन द प्रेसिडेंट ऑफ इंडिया थिंक दैट देयर मे बी अ वॉर होने की संभावना है, then even in the case of possibility of armed or armed rebellion or external aggression, the president can declare either actually those things are happening, or even if the government is feeling that those things can happen. So even in those situations, even in the possibility, president can issue the emergency, not necessary that thing should have occurred, right? So the answer is D. D is the correct one. All these three are the false ones. Question number 391. When a proclamation of emergency is issued by the president under Article 352 of the Constitution, fundamental rights are automatically suspended. Freedoms under Article 19 are automatically suspended, and other fundamental rights can be suspended by an order of the president. C. Freedoms under Article 19 are automatically suspended, and other fundamental rights except those under Article 20 and 21 can be suspended by an order of the president. D. Only freedoms under Article 19 are suspended, and other freedom or other fundamental rights cannot be suspended. Right? So Article 19 gets automatically suspended as per the provisions of Article 358. So 358 says कि अगर वॉर और एक्सटर्नल एग्रेशन के ग्राउंड पे नेशनल इमरजेंसी लगाई जाती है, then Article 19 gets automatically suspended. And there is another article of the Constitution, 359. It says all other articles, all other fundamental rights can be suspended, but by a separate declaration of the president. And there are two fundamental rights, that is 20 and 21, which cannot be suspended. Answer is C. Question number 392. Which of the following is correct statement? Proclamation of emergency in a state under Article 356 can continue beyond 1 year if the High Court of the state certifies the situation in the state is very serious. B. The governor of the state certifies that law and order situation is not under the control. The election commission certifies that it is difficult to hold the assembly elections. D. The president is satisfied about the grave situation in the state through independent investigation. So technically, Article 356 prescribes for the ground through which the state emergency can be imposed. So that says, Article 356 says, if there is a failure of constitutional machinery, precedent rules can be imposed or state emergency can be imposed. So this emergency can be for 6 months. It can be further extended for 6 months. So aisa karke it has 1 year. Now Constitution says, if Government of India, the Union wants to extend this emergency, if the President of India wants to extend this emergency beyond this period of 1 year, there has to be two grounds. One, there is already a national emergency imposed in India, or the election commission certifies that it is not practically possible to hold the election in a concerned state, right? So either of the two grounds are prevalent, then the state emergency can be extended beyond even the period of 1 year for a maximum period of 3 years, right? Answer here is C. Proclamation of emergency under Article 352. When Lok Sabha stands dissolved, has to be approved by Rajya Sabha, and then it will continue till the reconstitution of Lok Sabha, which must approve within the 30 days of the sitting. So ideally, once the national emergency has been imposed by the president on the written advice of the cabinet, it should get approved by both the houses of parliament within 1 month. And what is the majority required is special majority, right? But what if one of the house, that is Lok Sabha, that is dissolved during the time when emergency was proclaimed? So technically it should be approved within 1 month by the Rajya Sabha, and will wait till the date when Lok Sabha is getting reassembled, reconstituted, and from that date of reconstitution 30 days shall be given. Within 30 days it has to be approved by Lok Sabha also, otherwise on the expiration of 30 days emergency will lapse. So our answer is A. Question number 394 says, consider the following statements. Parliament may make law on a subject enumerated in the state list only if President deem fit it proper that such law is necessary. Proclamation of emergency under Article 352 is in operation. Lok Sabha passes a resolution by 2/3 majority. Governor of the state request the president for such. Now, अगर यहाँ पे राज्य सभा with the 2/3 majority होता, then this statement would have been true. So this is false statement. President may deem fit that such law is necessary. This is false. Proclamation of emergency. In that situation, we have already seen that if there is already a national emergency going on, the union can make the law. Union can make the law, right? So this is a true statement. Third one is false. Fourth one is also false. Answer is 2 alone is correct, right? Question number 395. Consider the following statement. A member of the Union Public Service Commission is debarred from appointment as a member, right? Second is, this is incorrect statement, that he cannot be appointed as a member again. That is, it should say, ineligible for any other employment under the central or the state government, is disqualified from becoming a constitutional functionary like governor. Right. So once a person has been appointed as the member of the UPSC, he is debarred from holding any other post. However, if a person who has been the member of the UPSC can become the chairman of the UPSC, there is no restriction on that, and there is also no restriction on holding any constitutional post. Right. There is no restriction on holding any constitutional posts. Right. So यहाँ पे क्या लिखा है? Member has been debarred from getting reappointed as a member. So this is true. Once a person has been appointed as a member of UPSC, He cannot be appointed as a member again. However, he can be appointed as the chairman. So that is first statement is true. Ineligible for any other employment under the government of the center or the government of the state. This is also true. Disqualified from holding a constitutional post. This is a false. So our statement shall be D. 1 and 2 is correct. Under the Constitution of India, the power to extend the functions of the Union Public Service Commission is given to the Parliament. Parliament can increase. Answer is B. 397 says, which of the following statement is correct? Union Public Service Commission may serve the needs of the state if requested by the governor of that state and approved by the president. Union Public Service Commission may serve the needs of the state if requested by the chief minister. Union Public Service Commission cannot serve the need of the state. Union Public Service Commission may serve the needs of the state simply on the request of governor and the approval of president is not necessary. तो क्या कभी यूपीएससी स्टेट के लिए एग्जामिनेशन कंडक्ट करा सकती है? The statement is true. Then when it can do? In the first situation, Union Public Service Commission may serve the needs of the state if requested by the governor and approved by the president. So this statement is true. First one. Now a bit of current affairs with regards to the National Crime Records Bureau. It is one of the agencies which is publishing every year the reports like crime in India, and it is also the agency which has been given the task for the implementation of CCTNS. You might have heard about crime and criminal CC tracking network system. So NCRB is implementing that only. And now NCRB is also implementing the flagship project of integrated criminal justice system that will not only include the police station but also forensic labs and judicial authorities like prosecutors and court at one places. So integrated criminal justice system. So दो questions उसी के ऊपर है. So let's see the first question about the NCRB. It functions under the Prime Minister Office. It was established in the year 1986 with the aim of establishing a body to compile and keep records of data. Collection, coordination and exchange of information on interstate and international crimes to the respective states is a function of NCRB, right? So first one that it says it functions under the Prime Minister Office is false because it functions under Ministry of Home Affairs. So NCRB, Delhi में ही है इसका headquarter. You go to the near airport, there we have. So and NCRB is also maintaining the database of central fingerprints. Fingerprints जब भी किसी का verification कराना होता है, so the departments and the various agencies will send it to the NCRB. ठीक है? So this is first statement is false. It functions under the Ministry of Home Affairs. Other two statements are true, right? NCRB के बारे में आपको एक चीज याद रखनी चाहिए that it releases the crime in India report, right? And there are a few details you will find that NCRB was established in 1986. And apart from collection, it has the coordination and exchange of information of interstate and international criminals. It also acts as the national warehouse for fingerprints. This is where I worked. NCRB report contains data received from 36 states and union territories across the country. So all the data are implemented in the crime and criminal network tracking system. और उसके बारे में जो second question है, consider the following statements about the crime and criminal tracking network system. It is a mission mode project under the National E-Governance Plan of Government of India. Its objective is to keep track of the progress of cases, including the courts. Integrated criminal justice system has been developed to include other pillars of the criminal justice system, namely courts, prison, prosecution, forensics, and fingerprint. So ICGS is also being implemented by NCRB itself, right? So the answer here is all of these three things are correct here. CCTNS के बारे में one thing you should know that there are two states, Rajasthan and one is Bihar. So they are not fully implementing the CCTNS. Rajasthan is implementing, but it is implementing in a different mode. Bihar के जो अपना software है that has been created by the NIC. So Bihar is not using the same software of CCTNS. However, Bihar is sharing certain data with the NCRB, but not they are using CCTNS. So CCTNS से ये दो स्टेट अभी बाहर हैं. Question 400, Samadhan is a doctrine. So Samadhan was a doctrine given by the Mr. Rajnath Singh, the minister. So it is related to left-wing extremism. So it is to control the left-wing extremism. There are various elements of समाधान जो यहाँ पे है. You can read smart leadership, aggressive strategy, motivation and training, actionable intelligence, dashboard-based key result, key performance indicator, harnessing technology, action plan, and no access to financing. So based upon these principles, समाधान is a strategy to counter the left-wing extremism. ये किस कॉन्टेक्स्ट में आया? तो अभी छत्तीसगढ़ में जो नक्सल अटैक हुए हैं उस कॉन्टेक्स्ट में इट वाज सीन. क्वेश्चन नंबर 401 विथ रेफरेंस टू द कॉन्स्टिट्यूशन 73rd अमेंडमेंट एक्ट. Statement 1 says, before the act, constitution only mentioned a two-tier form of government and the local institution found mention only in the DPSP. Second, it said state governments may devolve power for such bodies to implement schemes for economic development and social justice, authorize a parliament to levy, collect and appropriate taxes, duties and tolls, and provide for making such grant in aids to the panchayat from the consolidated fund of India. It mandates women representation in 1/3 of the seats. It noted that the state legislature would constitute a finance commission to review the financial position of the panchayat. यहाँ पे एक छोटा trivial सा mistake है. This is not a state legislature. This should be governor. So this makes this statement false, right? This statement, right? So बाकी जो fourth है that is false. Others are correct. Our answer shall be A. Question number 402. Which of the following is not a function of the Union Public Service Commission? It conducts examination for the appointment of services. It shall be consulted on the matters relating to the methods of recruitment. It shall be consulted on the disciplinary matters affecting a person serving the government of India. It shall be consulted in the case regards to reservation. So on all these three matters, UPSC shall be consulted, not here, right? So it is not a function of the UPSC. Question number 403 says, consider the following statements. Member of the State Public Service Commission can be removed by governor on the grounds of his misbehavior, president on the grounds of his infirmity of body, governor when such member becomes insolvent, president on the grounds of misbehavior after receiving reports of inquiry, right? Which of these statement is correct? Governor cannot remove the members of the State Public Service Commission. So those two statements become false. President can remove if he is become infirm with the body or mind, or if he has done misbehavior. In that case, an inquiry has to be conducted by the Supreme Court. So all these 2 and 4 is correct. Our answer shall be B. 404. Which of the following is the correct statement? Parliament may by law provide for the appointment of a joint public service commission to serve the needs of 2 or more states. A. When the president deems it necessary. B. When the governor of the state requests the center to appoint such commission. C. When a resolution to that effect is passed by each houses of the legislature of those states. D. When parliament deems necessary. So there is a provision of creation of a joint public service commission for 2 or more states. Then what is the process thereof? So it is mentioned in C. When each houses of the legislature, where there is bicameralism, both the houses of that state legislature shall pass a resolution. So answer shall be C. 405. Part 14A of the Constitution of India deals with the following: administrative tribunals. So there is 2 articles which have been inserted in our Constitution: 323A, 323B. So 323A talks about creation of administrative tribunal, and 323B talks about creation of tribunals for other matters. So let's see upon which of the matters the tribunals can be created. First, administrative tribunals. It can be created a trial by tribunal in the respect of informants of any tax. So income tax tribunal, any tax tribunal can be created. It is possible. Adjudication of trial by tribunals in the respect of sealing on another property. It is also possible. Adjudication or trial by tribunals in the respect of industrial and labor disputes. So a tribunal can be created on all these matters, right? इसका आर्टिकल 323 है अदर ए एंड अदर्स कैन बी क्रिएटेड अंडर आर्टिकल 323 बी. आंसर इज ए. Central Administrative Tribunal was set up on the recommendation of Central Administrative was set up on the basis of recommendation of Administrative Reform Commission. 407. Consider the following statement. A panchayat elected in the place of a dissolved one does not enjoy the full period but remains in office for the remaining period of the dissolution. We have already seen. In panchayat, seats are reserved for scheduled castes, scheduled tribes and women, but not for the backward classes of citizens. Right? So, scheduled castes, scheduled tribes and women के लिए reserved है. Scheduled castes and scheduled tribes in proportion to their population. Women, at least 1/3 of the seats are reserved. Right? So question number 407, both the statements are correct. Question number 408, in which of the following does the Union Public Service Commission advise the central government? On the matters relating to the method of recruitment to the civil services, on the principles to be followed in making appointment, on disciplinary matters in the respect of persons serving in the civil capacity, on seniority of cases. So, right, upon all these matters, UPSC advised to the government. Question number 409. Consider the following statement. According to Article 243D, 1/3 of the seats are reserved for the scheduled caste and scheduled tribes in every panchayat. Second, not less than 1/3 of the seat of the total number of the seats reserved for the scheduled caste in every panchayat are reserved for women belonging to the scheduled caste or scheduled tribes. Third says not less than 1/3 of the total number of offices of the chairperson at each level are reserved for women. So first statement is saying that 1/3 of seats are reserved for scheduled castes and scheduled tribes. So this statement is false. That says that they should be given reservation according to their proportion to their population. But jitni bhi seat hai, suppose that there is 100 seat and out of the 100 seat, 30 seats are reserved for scheduled castes and scheduled tribes. So out of this 30, further 1/3 should be reserved for women of scheduled caste and scheduled tribe. So this says that statement 2 is correct. Now not less than 1/3 of the seat. So women के लिए जो reservation है, that is saying that 1/3 of the seats for the chairpersons and also 1/3 of the members. So overall 1/3 seats minimum shall be reserved for every woman. So third statement is also correct. Let's see our options. What are the available options? 2 and 3. So 2 and 3 shall be correct option. Question number 410. It says, on which of the following subject does the Finance Commission of a state constituted under Part 9 of the Constitution of India make recommendation to the governor? Distribution between the state and the panchayat, the net proceeds of the taxes by the state. Second, determination of taxes which may be assigned or appropriated by the panchayats. Third, grant in aid to the panchayat from the consolidated fund of the state. इनमें से किनके ऊपर state की finance commission which shall recommend. So all of these are the part of the recommendations upon which the state finance commission makes the recommendations, right? Moving on, question number 411. It says, consider the following statement with respect to the 73rd amendment. It envisages the Gram Sabha as the foundation of Panchayati Raj system. It provides that the panchayat bodies will have a duration of 5 years. Third, it stipulates that the chairperson of panchayat shall be elected and from amongst the members thereof. Fourth, it has reserved 33% of the seats for other backward classes. There is no such reservation for other backward classes, right? There is no reservation for backward classes. It is only for scheduled castes, scheduled tribes and women which has been provided. Third, it's saying it stipulates that the chairperson of the panchayat shall be elected by from amongst the members of the elected members, right? It is saying that chairmans के लिए indirect elections होगा, which is a false. The chairman at the village level shall be directly elected as well. So this statement is also false. First and 2 are correct. Our answer shall be D. So first and 2 are correct. Question number 412, which of the following provisions can be made by law of a state legislature? Representation of the members of the House of the People in the Panchayat subject to fulfilling conditions. Second, reservation of the seats in any panchayat in the favor of backward classes. Third, authorizing a panchayat to levy, collect and appropriate their taxes. Right. So here all these statements are correct. Answer shall be 1, 2 and 3. Which of the following committees has recommended people's participation in community development program? So since we started implementing the CDP and National Extension Services, there was a committee which was formed to evaluate the performance of those schemes. That committee was Balwant Rai Mehta Committee, and it was the first committee which has provided for participations of people in the development program. Then after it came Ashok Rai Mehta Committee, then LM Singhvi Committee. So there are various committees which will be recommending few things. Balwant Rai Mehta Committee has also recommended to form a 3-tier Panchayati Raj institutions, right? Which was later recommended by Ashok Mehta that it should be not 3-tier, it should be 2-tier only. Moving on to question number 414, it says consider the following statement with regards to 73rd Amendment. Direct elections of the members at odd level, direct elections of the chairperson at the village level, indirect elections of the chairperson at the intermediate and the district level, mandatory provisions for holding the elections. Which of these are the provisions which have been mentioned as under 73rd Amendment Act? First, it is saying direct elections of members at all level. Second, it is saying direct elections of chairpersons at the village level. Third, indirect elections of the chairperson at the intermediate at village district level. And fourth, mandatory provisions for holding the elections. Right? Here our answer is D, 1, 3 and 4. Moving on to the last question for the day. Which one of the following government documents first suggested for the having elections of Panchayat Raj institution on a political party basis? किस कमेटी की रिपोर्ट ने बोला ये था कि पंचायती राज इलेक्शंस में भी पॉलिटिकल पार्टी शुड बी गिवन द रिकमेंडेशन? सो इट वाज अशोक मेहता कमिटी which was suggested. Ashok Mehta committee which has suggested. So far we have covered various topics like judiciary, executive, legislature, fundamental rights and emergency वगैरह भी हमने देख लिया. So now that we are left with some 80-90 questions, and that questions we are going to do specifically from the bare acts of the constitution, जहाँ से कभी कभी प्री में questions आ जाते हैं. So we'll be making the questions from bare acts directly. Those will be a bit factual in nature, but those are very important for you. You cannot simply go and read bare act. अभी शायद कुछ लोगों को समझने में दिक्कत होगी bare act. So we'll be making the questions upon them, and in the remaining question we'll also be targeting few most important current affairs. So join us in the next class where we'll be finishing off our RTFQ on polity. We'll be completing the whole 500 questions, and the handouts here you can download it from our Telegram channel, right? And as I told you, once we complete the whole 500 MCQs, सबके answer की explanation के साथ you'll be getting in our Telegram channel also. So thank you. Let's meet in the next.